Welcome. Good morning or good afternoon, depending on what part of the country you're in right now. My name is Candy Chambers with Direct Employers Association, and we're very excited to have you as part of our webinar today on proper use of applicant disposition status codes is critical in OFCCP audits. So we will go over a few housekeeping slides, and then I'll do some introductions of our presenters today. So if you have WebEx issues, just email Casey@directemployers.org, and that's K-A-C-I-E, and she'll be able to help you out. And if you have trouble with the audio broadcast on your computer, you can call in by phone. So just click the request phone button on the event panel. And due to the very large audience on today's webinar, all participants will be muted. This is one of our biggest webinars ever, so just be patient, but we'll get through all of your issues. So ask using the question and answer and chat sections of WebEx, and please just send your questions to all panelists. And we will go through those at the end of the session. All the questions will be read out, and if by chance, for some reason, we don't get through all of them, we will get them answered and sent out to everyone. This has been approved for HRCI and SHRM credits, so if you're interested in obtaining credit, just email Casey@directemployers.org. The same case, so that's pretty easy. The slides will be recorded, and they will be available on the pipeline, which is a social community for our members only, and you can access it at voice.directemployers.org. And if you want more compliance updates, just send the word compliance to the word compliance to 55678, and you'll get any weekend review tips, anything related to compliance will be sent to you with a link, and you can go look at it on your phone or your computer. And last but not least, if you want to tweet your event, use #DEChat. So let's start it, and let me introduce the webinar and our presenters. Many companies, as we probably know, fail to update and revise disposition status codes on a regular basis, and even fewer companies understand how to monitor and analyze the use of these codes by recruiters and hiring managers. Many companies are not prepared to defend rankings in applicant tracking systems, conduct component analyses, or any other types of issues related to your disposition codes. So this webinar will discuss the importance of the proper use of these codes so that your company is prepared to defend its decision making and let inferences of discrimination in the event of an OFCCP audit. Our presenter will also provide practical guidance on reviewing and monitoring disposition and status codes so that your company will be able to defend its hiring decisions and fully comply with the Internet applicant definition. Remember that these codes, the disposition codes, are keys to your success. So it's my pleasure to introduce our two presenters. We have Linda Cavanna-Wilk. Cavanna-Wilk. I always, for some reason, want to say that wrong, and I apologize. I hate when I get names incorrect. She's an employment attorney with FordHarrison, and she concentrates her practice on affirmative action, EEO compliance, and diversity. She's involved with affirmative action plan preparation, routine advice and counsel, client representation during OFCCP audits, diversity programs, and comp analyses. Can you imagine any more fun of a job than the one Linda has? She also assists companies with implementation of HRIS systems, applicant tracking programs, and employment testing. This is interesting to me because I didn't know this, but Linda teaches employment law and affirmative action courses at Cornell University, so that's quite a resume. She's also a board member of the Tri-State Diversity Council, and one of the reasons that we've asked her to present today is because she's a member of the Compliance Advisory Board for Direct Employers, and I'm very, very happy to have her with us today. She's presenting with one of her colleagues, Karen Tyner, who is also an employment attorney. She actually does management side work, and she focuses her practice on affirmative action, OFCCP compliance reviews, and affirmative action compliance. She works with federal contractors on developing APs and defending APs before the OFCCP. She trains HR, recruiters, and other managers on affirmative action obligations and OFCCP audit debriefs. She provides routine advice and counsel to corporate clients on applicant tracking systems, applicant data, compensation issues, and HRIS systems. And she presents a lot of seminars and webinars on various employment law topics such as affirmative action, diversity, FMLA, ADA, harassment, Title VII, EEOC, and OFCCP discrimination charges. You can see both of them focus a lot, though, on applicant tracking and applicant data and that sort of thing. So I think these will be two great presenters. And without further ado, it brings me great pleasure to introduce Linda and Karen to all of you. So I'm going to turn it over to you guys, and you can get started.
Thanks, Candy. Hello, everyone. Karen, I wanted to start by thanking you for taking the time to participate in today's webinar. As it implies, we hope to discuss and explain why we believe, as defense attorneys, these disposition codes and status codes are critical, both before and during an OFCCP audit. And, sorry, next slide, Karen. Before we begin the presentation, I'm going to spend a minute or two talking about the firm. I'm going to go through this quickly, but we did just want to let you know who we are and a little bit more about our background. Karen and I are both members of Ford & Harrison. It's an employment labor law firm. We have over 200 attorneys nationwide. The firm is a group of attorneys who specialize in affirmative action OFCCP diversity. We pride ourselves in the fact that our attorneys have great depth in this area. As Candy alluded to, crazy as it may sound, this group, we really love what we do. We enjoy working with contractors, and we really enjoy the compliance arena. Please be aware that this web, as with any webinar, is to help highlight issues, discuss strategies, and hopefully prompt you to evaluate specific issues within your organization. It should not be interpreted as specific legal advice for your organization. We went with an agenda, so you would know what to expect. While our focus is on the importance of accurate use and implementation of disposition codes and status codes, we feel that this is rooted in the employment laws, and so we felt as though we needed to begin with a discussion about the legal overview. Next, for those of you who are not intimately familiar, we're going to go through a quick discussion on the Internet applicant definition. Next, we're going to go into example status codes and disposition codes. And last but not least, we're going to talk about monitoring and how to monitor the results. Karen and I wouldn't be lawyers if we didn't feel the need, as I said, to talk about the law. Seriously, though, I think in my experience, contractors and even myself, we get so bogged down in the details that we kind of forget why these details are so important, why this got started. And at the end of the day, the affirmative action laws are anti-discrimination laws. And disposition codes and status codes, at the end of the day, are used almost exclusively to defend any inference or reception of discrimination. So you do have to remember that, and you have to go back to the law when you're thinking of your disposition codes and your status codes. Next one. There are generally two theories of discrimination. The first one I think people are probably more familiar with. That's disparate treatment. That is where an employer treats one or more individuals in a protected group less favorably than other individuals that are not in that protected group. This treatment requires the intent, and these theories are used OFCCP, EEOC, courts, name it, plaintiffs' attorneys. So this is the two types of theories of discrimination. We're going to focus primarily on the second type of discrimination. That's called disparate impact. This is essentially, in a nutshell, it's a neutral policy. It has the effect of eliminating one or more protected groups at a statistically significantly higher rate than other groups. So what do we mean by that? You may have, years ago there was a requirement that, for example, police officers be, 5'8". That didn't say that women couldn't be police officers, but it tended to rule out police officers and women at a much greater rate than men. So it's a neutral policy that has a discriminatory impact and effect. The Supreme Court, in a case called Hazelwood, where it stated in its that there are two or more standard deviations that be used in inference of discrimination. So again, impact where there are two or three or more standard deviations, that is an inference of discrimination. And I think that, I want to highlight that for a moment. So when you're in an OFCCP audit and you're all running your disparate impact analysis or your adverse impact analysis, whatever you call it, and you get a red flag that comes up, you mostly get it on the two standard deviations. And you know why you get it on the two standard deviations, because when the government OFCCP gets analyses, whether in hires, terminations, promotions, transfers, where there are two or more standard deviations, statisticians have said that that's no longer likely to be the result of chance, and the Supreme Court has said, and it can be used as an inference of discrimination. So now, it is up to the employer to rebut that inference of discrimination. In the 3 years, as many of you know, OFCCP has collected millions of dollars in settlement. And they've done it on exactly what I just described. And in my opinion, and I believe many employment lawyers, primarily it's record keeping, because as I just explained, the affirmative action laws like Title VII and ADA are anti-discrimination laws. And the courts have said where there are two or more standard deviations, it's an inference of discrimination. And so now it's up to the employer to rebut that inference of discrimination. And guess what? When you don't have records, there's no ability to rebut it. When your records are poor or inaccurate, there's no ability to rebut it. When their credibility is called into question, there's no ability to rebut it. So unfortunately, Karen and I live in this space quite a bit, where we get called in either in an audit or right before an audit where there's adverse impact or there's an allegation of an affected class, and the allegation comes from the fact that there were two or more standard deviations, and that was not able to be rebutted.
Hello, this is Karen. You've probably attended many webinars, many seminars talking about the Internet Applicant Rule. We've lived with it for many years now, but bear with me as I just briefly touch on it so that it will help us in our deeper discussion into status codes and disposition codes and eventually tie it up all together for you. So, there are 4 criteria or ingredients for the Internet applicant definition. They all must be met for somebody at the end of the day to be declared an Internet applicant for purposes of direct impact or adverse impact, as Linda was talking about. That in your AAP, your job groups are the building blocks for your APs. The Internet applicant rule is the building block for your disparate impact analysis. And this is why it's so important that disposition codes follow your Internet applicant definition. So what are the ingredients of Internet applicant? First one is an expression of interest electronically. That could be either through your applicant tracking system, go through the Internet some other way, or email, some other technology, electronic technology. That's an easy one. The next ingredient is the contractor considers the person for employment in a particular job. Consider is a unique term of art for OFCCP, and we'll talk about that in a minute. The third, the individual expresses an interest in the job, and they also have the basic qualifications for the position. We'll talk about that as well, because that's a unique definition under OFCCP regulations. And this one is the person hasn't removed themselves or withdrawn from the process. Talk about each of those separately. We'll talk about the first bullet because we're going to presume that's met electronic ATS system. So had he considered applicant, what does considered mean for OFCCP? Essentially means you open the application or you open the resume. But what's good as prong is the OFCCP does allow companies to limit the job seekers that we must count under disparate impact by using what they call data management technique or your established protocol or procedural barriers. So while it does mean you open the application, you get a large volume of job seekers, especially for entry-level jobs. I mean, you could get hundreds and hundreds for entry-level jobs. They're actually basic job qualifications. It's hard to eliminate them all in terms of assigning them a detailed disposition code. So to help us get through that, we use data management technique. As an example, if you have 300 individuals apply for a job, you're only going to look at the first 25 or the last 25 or every 10th one until you get to 25. So applying some random number to whittle down that number of applicants that you actually have to open and touch. So you take 25 out of 300, it's the 25 that you assign a status code and a disposition code to. The 275 you didn't open, you didn't touch. In CCP terms, you did not consider them, so you would assign them the code not considered. Well, they don't get moved over into your disparate impact analysis. What is to remember is that you inform your recruiters that we still maintain the application, we keep it for record keeping, but for disparate impact analysis, they don't proceed forward. So that's important. Considered is the unique term of art for OFCCP. But it also means that the job seeker, did they follow your rules? I call it the hoops the person must jump through in order to proceed further through your process. So this protocol established the rules. For instance, if you have a rule, we don't take applications through the ATS. We don't take applications through the mail or a hiring manager handing you a resume in the hallway. It has to be done through ATS, so that's a rule. Be consistent when you apply these rules. Another one would be don't accept applications when persons do not find the specific job they're applying for. But ATSs don't work that way, but in case you have one that allows individuals to fill in a job title blank, insist that there be an actual job title there. Otherwise, if they didn't follow the rule, they're not considered. There are lots of things that you can do. You can say that your rule is you must sign the electronic application. You complete the application. You must apply for the position the actual position you're seeking. For instance, seeking a part-time person and you applied for a full-time job. You didn't follow our rule. So protocols or rules for individuals to follow, and make sure your recruiters know what those rules are so that they can uniformly apply that for all candidates. So the wrong is basic qualifications. What are those? You're looking at the four corners of the application in this question about that applicant. Does Billy have the qualifications required for this job? What are you looking for? You're looking for skills, experience, education, that kind of thing. Likes to say that they should be able to look at the job seeker's four-corner document and determine whether or not that person meets the basic qualifications. In other words, it doesn't take your well-trained 10-year veteran recruiter to be the only one to be assessed whether or not the candidate meets the basic qualifications. How do you do that? Well, you have to have these basic qualifications established in advance. Your recruiters use them all the time. They post a vacancy on your website, they're listing job qualifications. When listed through the ESDS, they are also doing the same thing. They're identifying basic qualifications. So establish it in advance. Look at the advertisements. OFCCP will as well, and see if 5 years experience is required, or is it a preference? That's what I see hiring managers utilize, is the preference, and assigning that as a basic qualification. If I look at job advertisement on a client's website and its 5 years experience is preferred, or you must be able to speak Spanish as a preference, you don't then say that since Karen cannot speak Spanish, she's not qualified. Because not listed as a basic qualification. One thing that I hear from recruiters is hiring managers inform them that you're using the wrong job description, or the description where we get the basic qualifications. Well, somebody needs to make sure the recruiters are using the correct one. So get a process in place whereby you know that you're using the correct one. What I mean with true is celebratory, some name is still in the hat. Think about that. These candidates are in the hat, and they are filling them out to see if they're contended for the job. And if at time in that process, whether it's through the phone screen or in an interview, they say, I don't want this job anymore. For a reason, personal reasons, they don't like the salary, they don't like the hours, they took another job, something like that. They express tell you, I don't want the job. They can tell you in other ways. They can imply they don't want the job. They want them taken out of the hat. How that? Well, they show up for the interview. They don't return phone call. They don't return email. They come for the drug test. Things like that. So you keep records. These are disposition codes. So an internet applicant is somebody who's considered, who met the basic qualifications and didn't withdraw. These are to be used for your disposition codes. And I'll turn to Linda.
Thanks, Karen. Okay, so now we're going to turn to the codes themselves. How best to design a system. And at the end, we're going to talk about how to implement that system and how to monitor that system. At the beginning, it's very important to understand and tie back to these codes are supposed to be used to refute an allegation of discrimination or to define your applicant population. And just talked about the 4 criteria that help you define your applicant population. The discipline codes and the status codes have to be linked to that first, and second, an ability to refute an inference of discrimination to explain why you rejected the candidates that you rejected. Each system or company has its own disposition codes and status codes. Many times an ATS system that you purchase will have a set number of disposition codes or status codes. And it's important to look at those. It's important to refine those. And we'll talk about that in a minute. But let's talk about what is a status code. Many of you may not have heard that term at all. You've heard it as steps or levels or stages. And eventually, each company has its own process where we define, what the path is that each applicant takes, and the status codes are in place to try to track that. So again, many of you may not have heard of the term status codes. You may not have heard of the term levels, and it may be because your ATS system does not have it, or it may be that your ATS system has it, but you haven't looked at it and refined it. And how are status codes different than disposition codes? They are, and it's to create a path or a electronic a footprint for how every applicant went, and at what point an applicant fell off of the the system. Some of the sample codes that you guys will see. And again, I think this has to be refined and for your organization. But if you look, and in your ATS system does have status codes or calls them levels or steps, you see things like not considered, it's a new candidate, or did the hiring manager, or that the applicant had the phone screen, or that they sat for an assessment, or first interview, or second interview, or offer issued, or offer declined, etc. This will, for many ATS systems, and where I hope most of the ATS systems are going in the future, is they do not require the recruiter to populate these fields. like a disposition code typically takes a recruiter to populate. But for example, under the not considered or the new candidate, they're the greatest data management techniques that we've seen. If the applicant resume is not opened, then those individuals will automatically stay as new candidates, and they'll be deemed not considered. If a resume is open, it can indicate that they've been considered, and then a disposition code has to be assigned if they're rejected. If they're rejected and the recruiter sends them to the manager, then hopefully there's an electronic trail of that. In some cases, and when I say hopefully an electronic trail, is that in some cases status codes do have to be manually populated the same way that you see disposition codes manually populated. In honesty, I don't believe Karen and I have seen that those have as much success as the ones that have the electronic footprint. It is helpful for the not considered, and so for defining your applicant population, but it does always help you understand what step in the selection process the candidate fell out. Because in addition to having to give a disposition code, if recruiters also have to keep filling out status codes, experience it's less reliable. Big things that these status or messages are used for is what we call component analyses. Many of you may not have known, but since the Civil Rights Act of 1991, the law has required where you have bottom line adverse impact or disparate impact, and that means where you're hiring for a transporter job, and if you look at a year period, you have 2 or more standard deviations. Hiring against women, for example. So you have what's called bottom line disparate impact. So now you have to do what is called a step analysis or a component analysis. And that is essentially you have to drill down to identify what step in the selection process created the adverse impact. In the slide that I just referred to, was it in, between the phone screen and the first interview? Between the assessment and the first interview? Is that where, people were falling off? This, requirement has been in existence, as I mentioned, for a long time. The CCP is more recently focusing on it. I think Kim and I are seeing increasingly in our audits, the CCP will ask for step analyses or component analyses, but I have to tell you, we've been using them for a while. And why? Because if I have adverse impact against transporters as a whole, let's say my class is 100 people, people are rejected, and I have to look at an affected class for 100 people, I'm going to get some serious dollars. But if I can drill down to what step in the selection process created the adverse impact, it's for 2 significant reasons. One, if the step in the selection process was an effective step in the selection process, then I can use that to completely rebut the instance of discrimination that's drawn by the standard deviation finding. However, even if it is a subjective step, like an interview, I can still narrow my population. 100 people aren't going to have fallen off in the interview stage. They're going to have fallen off, maybe 20 are going to have fallen off at that point. So the status or stage codes are very important, and they're important because they help us define the pool. They help us, confirm and be sure that, what our disposition codes are saying are accurate, and also to do a step analysis. I guess for one moment, this isn't directly on the point of disposition codes or status codes, but I do think it's worth pointing, mentioning. You may be using pre-employment assessments. Is typically, if you look at a status code analysis and you look at where most of the people fell off, or quite frankly, where there's frequently adverse impact, it is frequently at the pre-employment step in an assessment. So if your analysis of your status codes is showing that that is where the adverse impact is, you have 2 choices. With no adverse impact, you can continue to use that pre-employment assessment. But where there is disparate impact, you either have to discontinue use of that employment tool, or you have to get that employment tool validated. Now, pre-tests have all been what I'll call low-hanging fruit for OFCCP, EOC, because especially cognitive tests have, shows that they do have a disparate impact on minority candidates. So now, as OFCCP is increasingly asking for component analyses, it's even more important that you're sure that your assessment is either creating disparate impact or it's validated. I also want to mention the applicant tracking system rankings. Many of us are here today because of the volume of applicants that we have now that we're on the internet. Before the internet, there wasn't the focus on disposition codes. There was probably nothing anyone ever heard of as status codes or step codes. And so even when you use all the criteria that Karen explained, you have the not considered, you have the people removed that didn't meet the basic qualifications, you don't consider the people that withdraw, you sometimes have a huge population of people to look at as recruiters. And so increasingly, we are seeing ranking systems in these ATS systems. So if 100 candidates pass the sample, the four criteria, they're filtered through their applicants, don't have time to look at 100. So they may only look at the top 10 that are deemed preferred or, better candidates, star candidates. And we want us to be aware that that could be deemed as an assessment. And if you're using that and it's creating adverse impact, you're going to have to look at either getting it validated or considering going to a random where you just look randomly at those 100 people, because rankings are interpreted as assessments in certain cases. And, again, not sure that we always defend that. Karen?
I think this is do you want me to go on the slide?
I covered this, but let me go over it for a moment. Okay. Again, the status codes are there to help us define the applicant pool, to put information about the applicant beyond the disposition code, to allow contractors to analyze the hiring process, and finally to identify the steps in a disparate impact analysis. Okay.
Codes. So you're on the witness stand, some attorney's asking you, why is Mary not hired for this job? You're in the disposition code, right? Or this is affectionately have called all these years reject reason. Disposition code answers why someone wasn't hired, and that could be, the reason could be they took themselves out of position, or you as a decision maker, you as the employer decide not to advance the person through the process. And one thing that's important to remember is that hired is a disposition. So hired for the job, and one thing that Linda and I, when we get into an audit situation especially, is the number of hired person identified on the applicant log does not match the number of person on the hire log. And usually the applicant log has far fewer persons identified as hired. And there could be lots of reasons for that because of the 12-month period you're using on the applicant log versus the hired log. But nonetheless, more times than not, the answer is that recruiters were not told when Billy or Mary was hired. So make sure there's a process in place whereby the recruiters are informed as to who was hired so that they can assign that as the appropriate disposition code. If you've been in an audit and during your initial run-through, let's say there's disparate impact for women, you look at position codes to help to refine the analysis. And what are you doing? Which is what Linda talked about at the beginning. You're helping to rebut any inference of discrimination. And the best tool and the best weapon that you have, and that is the reasons why persons weren't hired, Hopefully those reasons were identified contemporaneous with the decision, right? So the recruiters would not receive a phone call back when they're trying to set up an interview. The person wouldn't show up for the interview. The person said they don't want the job. The candidate wasn't qualified for the job. Those are decisions we want made, ideally, with, as we're looking at that application. So these disposition codes will have to determine who is the internet applicant and therefore who proceeds into our disparate impact analysis, helping inference of discrimination, and also defend any allegation of discrimination. And that's important is your ES is not unique, not only used for you in an OFCCP audit. It's just for an individual to file an EEOC charge against you for not hiring based on some kind of protected category, say disability. And if you're using disposition codes appropriately, your reason would reflect we didn't hire you because you didn't show up for the interview, or we called you and you never returned our call, or you told us you already had a job. You weren't qualified. So don't think that disposition codes are unique only for OFCCP. I'm going to turn to Linda.
Disposition codes, as Karen alluded to, should really reflect your company and your company's hiring process. As I mentioned before, ATS systems typically have recommended codes. I haven't ever seen that list is, exhaustive for companies. For other companies, it's too long. So you do get decision codes typically recommend that come with the ATS system, but we highly, highly recommend that you tailor them to your company. And also remember that you have two objectives here. One is to define the pool of applicants. We're going to use those disposition codes to define the pool of applicants. Who even gets analyzed for disparate impact purposes? Who even goes to the OFCCP? And second, as we've said, is to rebut an inference of discrimination. So we're going to go through a few sample codes, but I wanted to let you know at the outset that we recommend that the disposition codes parallel the 4 criteria of an applicant, internet applicant. So being not considered. I have recommend that companies organize them and put all the not considered codes together. And in fact, I recommend they put NC at the beginning, because one recruiter or one AA or officer who's running the data in 2015 may interpret as a not considered candidate. Maybe in 2016, the person running the data doesn't know that that's a not considered code. So for ease at the end of the year when you're running the data, we really recommend that it be organized according to the 4 criteria of the internet applicant, and also that that the initials are put there. So NC in this situation is those not considered. And for this company, they didn't consider applicants that were incomplete. They had a policy that says we're not going to consider them until they're complete. Obviously, you can't consider anyone who is age or not authorized to work in the United States, and the data management. And I think that as a general rule, you need to have enough codes that you can explain what is taking place in your organization. But you want to have too many codes that it's cumbersome. Karen, we were talking before, and she has some companies, clients where 10 codes is just perfect, and other companies where 40 codes works for them. So you don't want too many codes so that people aren't using them, but you do want them drilled down specific enough so they do absolutely reflect and mirror your recruitment process. Lack of codes or poor codes will all fail to explain, what's happening. The next step in internet applicant is doesn't meet the basic qualifications. And on these, we recommend putting BQ and organizing them, together so that, your recruiters will know that if this candidate isn't meeting the basic qualifications, why aren't they meeting the basic qualifications? And typically, a candidate, again, that has BQ is not someone that will ever get into the applicant pool. So the OCCP won't see this data. Right away, we're going to be screening out the NCs, the BQs, and you'll see in a minute the WDs. But with BQs and WDs, which are the withdrawal, we increasingly see the OIP asking about these and saying, who was, eliminated before you ran your disparate impact. So we think that it's recommended that you also have a couple, didn't meet the basic qualifications. Why? Was it experience? Was it education? Was it a former employee who's not eligible for rehire? Is it something else? And because, you're going to, when you're doing hiring for the position, it's be so obvious to the recruiter as to why that person didn't meet the basic qualifications. And I are involved, and we're called in, and we're in an OSCCP audit. That decision has been made, 12 months ago, 18 months ago, 24 months ago. And so either the recruiter or the hiring manager has left the company completely, so we don't know why they, interpreted that person to not meet the basic qualifications, or although sure they would remember, they didn't. And so again, we recommend that you have enough codes with meet the basic qualifications that if you were to look at it a year or 18 months from now, it would be clear to you as why they didn't meet the basic qualifications. The group that we recommend is those that withdrew. And here is one that I think, again, in my example, on the not considered, is an incomplete application not considered. When the individuals are running the applicant data at the end of the year, it is much easier for them if you've already defined who the withdrawals are. Someone who's running the data may not know that disinterested in someone's salary, or disinterested, in a position's salary would be deemed as a withdrawal. So NC come out right away, the BQs come out right away, and the WDs come out right away. And in your disposition codes, when you're designing them, if you put those initials at the beginning or something similar, it allows everybody to know how to run it. It doesn't really play much of a role in a recruiter always selecting it. It could, but it's really especially important on the tail end. What's important is to make sure you log those offers that were declined or offers that were rejected. It's very, very, very helpful to your employment lawyers at the tail end frequently. So, we've defined our population of applicants. We pulled out those that weren't considered. We pulled out those that didn't meet the basic qualifications or those that withdrew. And we have, for example, adverse impact against Asians or against Asians. And so one of the first things that your employment attorneys are likely to look at is, did we give any Asian candidates offers? And so you'll want to know right away who those candidates were that either declined the offer or the offer was revoked because of, screening or background check. But at least we'll know whether we can refute it right away by saying, look, there were 4 Asian candidates that were given offers, but they didn't accept the job. Last but not least is the code not qualified. I left this for last because it's very important, and is that you find not best qualified, as well as you can. And you not just say wasn't a good fit, didn't interview well, et cetera, but you be as specific as you can. Was it education? Was it lack of sufficient interest in the job? Was it skills? Was it experience? A sample list of not best qualified candidate reasons. But you have to know that when you do a disparate impact analysis and you've removed your NCs and your WDs and your BQs, really all you have left is your not best qualified and your hires. So if somebody wasn't hired, we know they weren't the best qualified candidate. And if we're going to rebut an inference of discrimination, we need to know why they weren't the best qualified candidate. Doesn't fit, those type of things don't help, and just a general NBQ doesn't help. So we sometimes have clients that put in NBQ other. We recommend that be very, very used sparingly. Back to you.
Okay, thank you. So talk a little bit about monitoring and training. So I'll receive that audit letter before, you gathered your AAP data, you've gathered your supporting data and other information, and now you're running your adverse impact, and lo and behold, you find that you have disparate impact in a job title. So what are you going to do? Now you're panicked, right? Because it's audit material due. And now to the disposition codes to see if you can refine that data further, you just have many missing disposition codes. And like it says, it could be that you have a new recruiting team or your hiring managers have changed, and it's just very difficult to go back months later to determine why these individuals, why these candidates were not hired. So in panic during an audit, we're reliant that you monitor your disposition codes, especially during the year. It's better to get that out of me and see what's happening so your ATS system is being used like it should. And one component of monitoring is definitely training your personnel. Well, who's going to train? With decisions in the hiring process, human resources director, generalist within the HR department, recruiters. I mean, definitely them. They're pre-screening many times. Managers, for certain, involved in the hiring process in terms of making a decision, not in terms of just checking a box like the drug screen, but someone who makes a decision. Training them on, just like we've been talking about, you're training them on the why. Why doing what you're doing? I remember 20 years ago when I learned how to do affirmative action plans, it was by hand, and to go down to the unemployment office to get your census data. And when I learned how to do them by hand, I started to appreciate the why. Especially, it came in handy when we got computerized, and I knew why I was doing what I was doing. So I'm big on explaining to people, why are you doing it? Why is what you do important to us? And so it takes is bad audit when you have disparate impact in your largest job title, your highest turnover job title, with very few, if any, basic qualifications, and everybody's listed as not best qualified. Have in their hires and not best qualified. Now there are hundreds of applications that recruiters and hiring managers go through in order for us to see if we can refine our disparate impact analysis. And it only takes that one bad experience for recruiters to become converts, right? And they start understanding the why. And you explain to them information on disposition codes and status codes, if you have that in your ATS. That's crucial for us in mud and inference of discrimination. It's so crucial for us if we have to face an EC charge for, say, disability. So it's just very important for them to know why they're doing it. So time. You have your AAP on an annual basis, so you're running your analysis on an annual basis, but we'll do it 6 months later. Let's do a checkup. Let's do a monitor checkup. It's important to meet with recruiters. You may have 10 recruiters, and 8 of them are doing it a great job, and 2 of them are not. So it's like in the old days and when my law firm used total quality management. You don't bring everybody in to tell them, well, you're doing X wrong when not everybody's doing X wrong. So meet recruiters who are not using the tools appropriately to teach them further what they should be doing. Monitoring, beginning, the status and disposition codes are critical when you face disparate impact. Your disposition codes are your weapon to whittle down who's an internet applicant and help you when you face these discrimination allegations and inference of discrimination. So when you're going to monitor, the answer for a shortcut is all of the above, not just during an audit. You have adverse impact, and just on an annual basis. You're going to do all. You do it on all of the above. And like we prefer that it be done every 6 months. Just satisfy HR and C-suite management team that we're utilizing our TS system appropriately, and the team is as well. Monitor. You're going to look at all areas which can create disparate impact. Linda talked to you about the steps or the stages. For instance, in the pre-employment testing arena, we see a lot of disparate impact there. The interview stage, if people drop off there, well, why are they dropping off? The phone screen stage, why are they dropping off there? So what are you doing? Well, you're running your report ATS. Let's say you're doing it every 6 months. Pivot table, a simple pivot table from Excel, show you the status codes that are used and then the disposition codes that are used. You'll see where they're being distributed. Are they pretty evenly distributed, or where are you weak? Where are you strong? Where do you owe a recruiter a pat on the back? Was telling me before, one of her clients was gift cards to get to recruiters and hiring managers when they improve on their use of disposition codes. So find ways to be creative in encouraging recruiters to use this tool effectively to your AS system and your disposition codes correctly. And realize as you keep monitoring, your spots disappear. And you might get new weak spots, but your old weak spots hopefully disappear, and so you're getting cleaner and cleaner data. What is this slide representing? These are disposition code summaries from one of our clients of 2 of their different facilities, 2 locations. And just so you'll see top that the location on the left has 1,300 disposition code or job seekers with no disposition code. This is 3,900. That's a lot of people. And then here you'll see that on the left-hand side, 1,351 have NBQ Other. So talking about NBQ Other may have been a default, may have been laziness by recruiters just to pick a disposition to get the requisition closed out. But 2,600 people had disparate impact. That's 2,600 people that might help you in your rebutting your inference of discrimination. And you were in an audit and you have different disparate impact, you might your recruiters and your hiring managers looking over 2,600 applications to see if these 1,300 blanks, where do they fit in? Where's reject reason? But on the inside, you see kind of similar numbers. There's 1,000 blanks. That's not good. They're NBQ Other, but here at management, consider data management or high volume. They are really, these recruiters over on this facility are doing a great job of utilizing that tool. And the one left is doing an okay job. They could probably do better of using that tool. So it's a demonstration of what a simple pivot table will show you on the distribution of your disposition codes.
Interesting.
Oh.
Ken, I wanted to share with the group, and I know we're running out of time, so I'm going to say it quickly, though, this was a client of mine, and they had done a lot of detailed work in identifying the disposition codes, designing the disposition codes, training the recruiters, and yet a year later, they were surprised, and even the recruiters were surprised with these distributions. And when you do their training and you have these kind of numbers, it's much more meaningful to the recruiters. They thought just, each of them not identifying a few disposition codes wasn't a big deal, but they were able to see how to add it up. They were able to, be in a room together and understand that the NBQ there was really the fact that they had put in an assessment since codes were designed, and there was an assessment code, so everybody was doing another. But that didn't mean that, they were all assessments. So, a year after this, we reran the pivot tables, and as Karen said, it got better a year later. And there were still tweaking to be done. There were codes taken away, new recruiters who were, coming up to speed. But I think if you give actual numbers, it's very telling. To just, sum up, so we have a little bit of time to give you guys answer questions. Understanding that this is all helping you explain away discrimination. It's helping you explain how someone, progressed through the hiring process, when they dropped off, why they dropped off. Note your disposition codes have to reflect your organization. Your status code should mirror how you do your hiring. Your organization does your hiring, and proper training of ATS users and hiring managers and monitoring couldn't be overstated.
Now, questions.
Okay.
Are there any questions?
We have lots of questions. Obviously a very big topic, so let me just go ahead and get started, and you guys can just decide who wants to answer. Is there any OFCCP requirement, and this is probably my favorite question, to collect interview feedback notes from hiring managers, provided that you don't collect it for any of your recs and you assign proper disposition code for all viewed applicants? It's like less risk exposure to have, and that they cut off. So, but basically, should you keep interview notes?
Well, they had an audit in which we discovered we had disparate impact in a job title, and we discovered that the department head had notes and only had notes for a few of the candidates, not all. And I'll make up a number. They had 100 individuals interviewed. We only had notes for 15, but there were disposition codes for all 100 that some of them would have reflected information passed on to the hiring manager during the interview. For instance, the individual would have said, "Oh, I don't want to work on call. Oh, I want weekend shift, or I don't want weekend shift." But in of information the hiring manager would have put down on the interview notes, and I had no way to back it up. And the OFCCP said, well, if you had interview notes, I would believe you, but without interview notes, I don't believe you. And just an EEOC charge and the lawsuit of a document can be inferred against you. So I keep interview notes. If you're going to use them, you need to keep them.
Well, first of the question was broken into two different questions, and it was down a little ways. There was, if you don't have a business process that requires them, is it better to not include them because then it could be hit or miss? So how would you address that?
I think, Candy, the short answer to that is if interview notes are made, they should be kept. The regulations say that notes have to be kept. So, we would tell you to either probably have a process or not make the interview notes. But, interview notes are very helpful. Obviously, not time. We've all seen that interview note that, scared us.
They saved me.
But if you make the note, you have to keep it. But we do recommend that the company have a process for interview notes, either a questionnaire or something.
Okay. Analysis shows adverse impact greater than 2 standard deviations. What is the best way to document facts or explain events that support that it did not due to discrimination?
I think Karen would give you the same answer. It's really what we've talked about. First, look at your pool of applicants. Pool of applicants include anybody that doesn't meet the Internet applicant rule. Have anybody who's not considered, who withdrew. So one, look to your applicant pool and make sure that it's accurate. And then second, look at why the rejection reasons were, and try component analysis, or try to do a breakout. See where people dropped off. Were they dropping off because they failed the drug screen, which clearly isn't discriminatory? They fall off in the interview. And does the rejection reasons adequately rebut the inference of discrimination? When I say rebut, do the rejection reasons adequately explain away the discrimination? And then also look at your offers. Maybe, the class that has adverse impact did get several offers.
Thank you. Okay, regarding Internet applicant, it is our procedure to consider an applicant when they have entered for the position, that they applied for the role. Will this pass the OFCCP muster?
This is Karen. That's always a good question, and I think I've heard it asked several times at other events that I attend. And the bottom line is OFCCP does not think that an applicant, an internet applicant, are only those persons who make it to the interview. Because, you know, you pre-screened them before the interview for lots of reasons they dropped off. So I don't think I'm going to let you just say, if you make it to the interview stage and beyond, we're going to consider internet applicant.
Does a federal contractor have to establish a data management technique ahead of time before posting a job opening, or can that be done after resumes have been received, i.e. after the fact? And I'm going to take that one step further. I think that's probably, well, I'm going to let you guys answer that, because probably you're going to answer it the same way, but go ahead. You're the professional here.
You know, I don't know what Karen would say. I would say it's tricky. I would say as a general rule, I would want to recommend that data management techniques are established beforehand, because I think that there should be consistency. You know, it's high volume jobs. Are we only going to look at the first 75, or are we going to look at the first 100? We don't want some recruiters looking at the first 25, others looking at the first 50. I mean, the bottom line is we're probably still safe anyway. We're only looking at what we're looking at, but I think that, you know, the OFCCP would potentially, you know, argue with me over that issue. So yes, I think the base scenario is to do beforehand. But if you have 1,000 applications and you've never had 1,000 applications before, and you're never going to look at 1,000 applications, do a really good job of documenting those applications that you looked at and those that weren't considered. And status codes, an ATS system that electronically monitors that will help you with that. Can't agree?
Yeah, that I would say, you know, the only difference would be if you have an opening that only has, you know, 20 job seekers that applied to the position, then if you have a data management technique decision, look at the first, up to the first 50, you're over, you'd obviously look at all of them. So
right.
I agree, you need to have a process in place. That's my biggest, is to always have an employment process so you know what your expectations are. Mm-hmm. Here's one of my favorite questions that I receive probably every couple of weeks. Job descriptions. How much change in a job description will require the employer to repost the role or send the new job description to the applicants? Take that a step further. If the requirements of the position are reduced, or if the requirements of the position are increased, should you take on and repost, or should you just leave it up there and send the new job description to the people who have already applied?
See, so let's say we have a job advertisement on our website, and it says 5 years experience in, say, the NICU. We can't. None of our candidates, 100 people apply, nobody satisfies that requirement. So as a company, we'll say, well, we're going to lower the bar, and we're going to say only 2 years minimum experience. You go back to those same 100 candidates, and you apply that new lowered bar to those 100 candidates and see if, you know, normal process. I wouldn't think you'd have to repost that. You know, I mean, the way I look at it is I want recruiters to fulfill their obligation and to hire the talent with a reasonable time frame. And if you back and reopen the acquisition and repost it, now you've just delayed hiring, and maybe you have a really urgent need.
The only issue have brought up to some of our members is this, and this happened in my own company when I worked before, is that you will have some people that will look at a job description and say, oh, it's requiring 5 years of experience. I only have 3. I'm not going to apply. Right. So then if you reduce the qualifications to 2 and you say, oh, gosh, I could have applied. So you could still be losing some very potentially qualified candidates that you wouldn't get if you didn't repost.
Mm-hmm.
So that, you know,
I totally get that. I get that, but I think what's your need? What's your
I think
need?
it's a judgment call, right?
Yeah, exactly. Okay, so I think you guys will enjoy this one. When I close a position, I have been dispositioning everyone with more qualified candidates selected. Do I not need that moving forward?
This is Linda. You know, I think that unfortunately you're not going to give your, you know, compliance defense team the they need to defend you if that's the case. And you know, this isn't the question. It does remind me of something. You know, what I see is a lot of ATS systems that, you can't leave the disposition codes blank and still hire. So, have to fill them in, and they do these batch codings. Or you do this, a better qualified candidate selected. And what happens is, I don't know why a better qualified candidate selected. So I'm asked the recruiters or the managers to go back 12, 18 months later and tell me, okay, what about this resume makes this person not as qualified as the person hired? And it may not have been on the resume. It might have been, their demeanor or how they dressed or, their skills or something that's not on the application. And now I'm just left to the application. And if it's a highly skilled job, it might be apparent, but if it's an entry-level job, like a Monday morning quarterback 12 months later is a real, 24 months later is a real problem. So we probably won't have much to rebut that inference of discrimination. So then we're trying to do step analysis, and we may not be able to do that. Batch, I would say, though, batching and disposition codes is even worse because you're getting a code like, skill, and you're just giving everybody the skill. And we don't know who was batch disposition code and who really, wasn't selected because of their skill. So it really calls, when readers are doing batch coding, it really calls all the codes into question and credibility in front of the OFCCP.
I agree. I had actually given your same example last month when I did a very similar webinar or presentation, and a lot of times you have to consider recruiters turnover and sometimes just move up into the organization, but they're a group of people that have a lot of opportunity because of all the people that they meet. And you need to consider that a person who was the recruiter that filled out that application or filled out the disposition code might not be there a year later, and you do have to be able to have anybody understand that person was selected. So we have still quite a few questions, and I know we are over the time limit, so people can stay on. I would love to have people stay on. We will stick these questions out to folks just so they have that information in case they had to drop off because of the scheduled time of the webinar. So this is how do we classify candidates who are overqualified?
I mean, really, they meet the basic qualifications of the position. So an overqualified candidate, is a problem, and not a problem, but is a challenge, I would say, because if they meet the basic qualifications of the job, and you considered them, and they didn't withdraw because they salary or the position, then they are a qualified candidate, and you need to consider why you're not hiring them. And if you're not hiring them because they're overqualified, that can sometimes be challenging or with issues because it may have a impact against older workers. So, in fact, what I tell people as an employment lawyer is if they're applying for the job, if you let them know what the salary is and they continue to be interested in the job, then don't stop because you believe they're overqualified.
Okay. In reference to the four corners of job criteria, and I'm assuming that this is the applicant rule. In experience, does OFCCP focus on any one or more of the criteria? If an organization assigns a weight to, I guess I didn't read it all. If an organization assigns a weight to each of the criteria, how does the company defend their self-imposed weight?
I think the job skills or the job requirements criteria for an internet applicant.
Yeah, I think I misread it.
Yeah.
I'm a person that said, so why don't we talk about that one later, since we're all kind of unclear as to what that one meant. TS ranking has validation implications, but it is subjective, so all ranked are considered and most meet basic qualifications. We are all in an applicant pool now because you assessed, right?
Anybody who, even people who aren't ranked at the top are still basic, met the basic qualifications. So they still will be in the applicant pool. My example, you have 100 in the applicant pool, and you have 10, ranked as highly really qualified for the position. And that may be because you asked for a college degree and they, came from Harvard. You asked for 5 years of experience and they have 8 years of experience. So it's great that these systems can give us information without having to go through all 100 candidates. But you have to know that, validations of assessments involved, and it has to be able to prove that these traits would increase the success of performance on the job. And so I think that what is being challenged, I'm seeing more and more in these audits, is these ranking systems are being challenged. And they're saying, why didn't you look at all the other people? Why did you look at these first 10 people every time? So it's not that it's unlawful by any stretch of the imagination, but it is creating a ranking, and that ranking system may or may not be validated.
Okay. If it indicates on an internet pre-screen question that the desired salary is higher than our range, how do we classify that person? As a withdrawal?
Client that asks salary, the way it's phrased on the application is your salary preference. And that's kind of wishy-washy, and by somebody indicating their preference is, say, $15, job high range is only 10 for hires, and they're automatically pulling those people out and calling them a withdrawal. I would call them a withdrawal. I think that's appropriate. That's how OFCCP would in them. They would say that they withdrew because their salary demands were too high. But look how you phrase it. Is it a preference, or is it more of I must have this minimum salary in order to come and work for you as a job title X? So look how you phrase it. I classify them as a withdrawal.
Okay. So if you did to view every 10 resumes, where do you document your strategy for reviewing resumes? And I mean, I'll just add, I would go back to having a written employment process. I mean, do you guys agree?
I do.
Okay.
I think that, every 10 or, and want the recruiter selecting which 10. If it's, it'd be a process where it's first in, versus first out, first ones to apply, or the computer gives me a random selection, or I wouldn't want the selection of those that we consider be challenged as discriminatory. So I would want the system established beforehand.
Needs to be an objective
process. Right.
I have a that has a routine number, and the recruiters know that they need to use, let's say, 25 data management technique, and they have an unusual, like you said earlier, if they have unusual high volume in one job title, say 1,000, the recruiter can go to the supervisor and say, can I limit it even more? And they will make a note of that in the requisition piece of their ATS system.
And it's smart, I think. This is a good one. I like this one too. Do parents recommend that recruiters or hiring managers be allowed to add comments to the codes for further explanation? So, can these comments be excluded if further information is requested from OFCCP during review? That's a question.
It is. I mean, I think the second part of the question is easier to answer. No. If you're putting the comments in and the government's asking for information, it has to be produced. Again, it's any record that's made, time of the hiring decision. Any record has to be maintained for the requisite period of time, and that they're asking has to be produced. So really, this question goes back to a little bit, my point at the interview, and that is, if you are using an other code, NBQ other, or something else that's other, I do like a brief explanation. What was it that was other? What made it not fit into the ones above? But it's clearly something that HR or EO should be monitoring, because we have seen the comments on, in these sections, walk too slow, didn't speak English clearly, and so the bottom line is disposition codes and being able to stay within the constraint avoids comments that on their face could look discriminatory. So in the other, I'd like to use it, but I'd only get them, give them space for a limited number of characters. It will have to be produced, and HR and EO people should be looking at what's being put in those others.
Well, I'm going to take this one additional step I would be interested to see if the attorneys on the line would agree with this, but it would all depend in my situation if I was responding to a CCP audit and all the information was requested. If the FCCP asked me for a list of job seekers and applicants' disposition codes, I give them the disposition codes.
Agreed.
Additional comments were not, if they said codes and comments, I'd have to give it to them. But they just said codes, I'd give it. So anyway.
Excellent clarification. Yes, I agree with you. So they did ask for it, but they specifically asked for it. We can't hold it back, in my opinion.
Exactly. Oh, I'm right there with you. Okay, can you explain again where in the process the data management technique should be used and how it should be used? Hit a couple of times. I think you need to have that defined in your employment process. And
but I think the question, the person who asked the question is asking, like, what is it? And it's really at the beginning of the process. We don't typically recommend data management techniques be applied after the fact. So, you would really do it, again, meet specifications and do it at the beginning.
Okay. This is a good one. When an offer is made to an applicant, but they fail or do not show for the drug test or do not show for the first day of work, should they be included as hire when counting applicants for the adverse impact, or since they withdrew, should they not be? Good question.
That's a good question.
For the test, I have a client that has about 60 or so disposition codes, and they have one that says hired dash failed drug test, hired dash failed background test check, and that's letting them know in the HR side that Bill Mary was offered a job and they were hired and they went further in the process, and this is where they fell out. Linda talked about before, do we want that offer at higher during our disparate impact analysis? So I think that's helpful to know how far got, and you call them or count them as a hire is really just going to depend. A lot of OFCCP is asking us break down hires versus your offers. But I think if you call them your hire.
Yeah, I definitely wouldn't consider them rejected. I wouldn't consider them rejected. So I would either, put in the analysis as Karen said, and treat, the analysis is an offers and hires analysis, or I would as withdrawn and not have them as applicants or, rejected or hired. And that's up for debate, but I do think that we do have the flexibility to do it, either way.
This is a good, I get this question a lot. Do you recommend allowing recruiters to collect resumes at job fairs or other events? I don't know if you guys have risk to that. I do, if you want me to answer, if you guys have a...
Go ahead, Candy.
Well, I do a lot of college recruiting. I think everyone, there's nothing worse for a college student than to go up to a booth and have the lawyers say, well, we don't take resumes, you have to apply online. And I'm a firm believer that by collecting the resume, you can take a look at it, but tell them, because you have that written employment process, that only people who apply online are considered for employment purposes. So if you reach out to the people, say, or tell them, we'll take your resume and take a look at it, but to be formally considered, you will need to apply online, blah, blah, blah. So then you have to actually consider them unless you truly have followed your outlined employment process. Do you guys...
What I'm saying, yeah, I absolutely agree, because you can't deviate from your employment process where you're going to subject, you're going to open applicant pool significantly. But I'm seeing, and I don't know if there's something you're seeing, I'm seeing increasingly iPads and computers right at job fairs. So that's kind of helps eliminate that issue. But Andy said, you can't stand there and give them information about the company and not take any information, but you can't violate your process. So you have to find out a way to do it in between.
Okay, you mentioned the need to validate assessment tools. How might one go about validating a ranking tool like the ACE candidate functionality in Taleo?
That longer conversation than we
That's
have
kind of what I
time
thought
for in this question.
I know who asked that question, so I will pass that along and we can maybe have a conversation. Do you recommend adding rejection details in the ATS, or is it better to simply use the disposition code? It's kind of what we talked about before with comments. I would make your disposition codes as specific as possible. Do you guys agree?
If you train your recruiters on the disposition codes, let's tell you, I mean, have a monthly meeting, and they may tell you, look, this doesn't work. Like Linda said, people were in NBQ other because, well, we started an assessment tool and we didn't have a bucket to put them in. Listen to recruiters and tweak your ATS as you go. You can't just use your ATS off the shelf and you fit you.
Exactly. Show disparate impacts for specific job recs. Should you go through specific app flow logs for each of those jobs? What exactly would you be looking for?
Can you read that, Andy? I'm sorry.
Sure. If you show disparate impact for specific job recs, should you go through specific app flow logs for each of those jobs? What exactly would you be looking for?
That one. There's quite a bit, right? We do.
You have to be consistent. You're looking for your disposition codes. And if I have adverse impact in, say, a job title, that level job, and it's got a large volume of applications, that's where I'm going to focus, and I'm going to look only and figure out my disposition codes, which ones can I remove based on either not considered, they're not qualified, they withdrew, and there are a bunch of holes. If I have a bunch of blank disposition codes, I go back to hiring managers and I say, why these people weren't hired. And I have to be consistent. If they're going to tell me, well, this person applied for a part-time and it was really a full-time job, or vice versa, I have to go back to the well and make sure you didn't hire people who needed that, quote, need. So not just at that specific job title, but I'm consistent in the way I apply my disposition codes.
Okay. If we use a separate interview evaluation, which we save, is it okay to toss the notes? I've got a question before. I want your guys' answer.
I don't understand what that means.
Okay, so I think probably it's a separate interview evaluation, which we save. Is it okay to toss the notes? So probably the handwritten notes. I know that we used to use a behavioral interviewing calibration tool. So we would have the calibration, and people would have their own individual notes, but then they would have a meeting and have a calibration meeting and determine at meeting who the final candidate was going to be. So I think that question is related to, is it okay to toss each individual interviewer's notes?
I think the courts, and Karen, jump in if you disagree, I think the courts would want sure that you have captured everything in those notes. So, telling us that you're just keeping it in a different form, an electronic form versus scribbled note form, but that you're capturing everything that was on the notes, I think you don't need to keep it. And I would bet that most people aren't keeping them. But I do think that, if court looked at it, they'd the record retention obligation is that, anything made, part of the decision is retained for 2 years.
Mm-hmm. I'm a stickler for keeping them. So.
Okay. I'm going to ask that we finish this up in 7 minutes, which I guess in 6 minutes, which will be 3:30. I apologize that we've gone longer, but I hope the comments seeing have been very positive. So I think those of you who are able to stay on, I think that's great. I have a few more questions. If you have a pool of applicants who all meet minimum requirements, but a few who meet both minimum and preferred requirements, you disqualify those who only meet minimum qualifications as others are more qualified. Interesting question. I'm glad I'm not getting some of these.
I have to read it, so go ahead.
I mean, yes, but I'd want you to, tell me why those people who are only minimally qualified are only minimally qualified. Is it education? Is it their licenses? Is it their experience? So what is it that makes, the preferred candidate a preferred candidate and the not preferred candidate not preferred? So I wouldn't want to say, well, the preferred candidates were more qualified. I'd want you to help tell me why they were more qualified.
Mm-hmm. No, I get why you call it a preference.
Some meat to your disposition code to somebody understand what it was.
Right.
I think I want to clarify something here because I think somebody maybe misunderstood, and I don't remember which one of us said this. I said something similar, but it was mentioned that a data management technique could be to view every 10th resume until you reach a total of 20. Would that pass scrutiny, or did you not articulate that example clearly? That was mine. I didn't say it that way. I said you might look at the first. You had 20 candidates, you might look at the first 10, or something like that. So I never said skip over every 10th. I don't know if Linda or Karen, if you had said that. I didn't pick up on that.
Karen, I said that, your management technique might be that you're to look at 25 and you look at a 10th one until you reach 25.
Oh, okay. Okay.
So you're assigning a random number to reach your total.
Okay, to do a random selection. Got it.
Right.
Okay.
Right.
I think it was a sample of a random selection.
Okay.
Right.
As opposed to the first 25 that come in. Is your algorithm picking, the 25 that you get? Are you going to pick the first 25 that apply, or are you going to do something like, Karen mentioned? So it's just, it was that, supposedly unbiased selection process.
Mm-hmm.
Okay. Interesting. Regarding not reviewed candidates during the application process via ATS, is it okay if you leave the status as not reviewed, or do you need to change it to not considered? Typically, it happens once we are down the road in the interview process. And then to follow up on that question, if they are listed as not reviewed, do they have to have a disposition such as received late in process, etc.?
So you're saying the question was asking if status code says not reviewed, does the recruiter have to move that person along? Do they have to indicate that they were not considered, and do they have to disposition code them?
Not reviewed, you still have to disposition, basically.
I think the answer is no. And people may disagree with me, but I think the answer is no, and I think that's one of the benefits of having a status code and a system that logs status codes, because recruiters have so much to do as far as record keeping, and let's let the computer do it for us. We didn't look at those people. They're not going to ever get the applicant system. We're going to be able to show the OFCCP that we didn't look at them. So I don't want to open it and assign a disposition code or make something up, because the bottom line is I didn't look at it.
Mm-hmm.
Exactly. What are your thoughts on HireView, the software that uses video conference for pre-screens?
Yes, I'm not familiar with that, Candy. I apologize.
Well, and I saw it when I was still at Cardinal Health. It makes me nervous, but then of it say, well, what's the difference if they walk in your front door and interview site? So we'll leave it out there.
But I would tell you that the pre-screened people are obviously meeting the basic qualifications and need to solicit race and sex and probably just disposition code them. Is that who those video people? Yeah.
Yeah, definitely.
I looked at that, and not as a demo or anything, but I think that they're really things as far as making it disabled person friendly. So I think that they're ahead of the game from that perspective, and I think it's more starting to use that pre-screen video conference.
Okay, here's kind of an interesting one. I have a funny story as to what happened when in personal experience, not personal experience, what a hiring manager told me or a HR person told me they did. If an employee refers a friend or a recruiter met someone at a job fair and referred them to apply, how do you view their application if you use a data management technique? I'm going to go ahead and I'll share the story that I had to deal with.
Well, a client that had a great referral process, and they rewarded employees and then potential new hires. Referral process, and they wanted to marry it with their data management technique. And what they did is we blended them. We said, your management technique, I'm making up the number, you're going to take the first 25 or every 10th one until you reach 25, and then all referrals. And their ATS system allowed them to also pull out all referrals. So meant was we had 25 people who were, quote, considered along with all referrals. That might be 100 people. That's how they wanted to try it on. I said, try on a pair of shoes. If it fits a month, just keep wearing it. If it doesn't fit, use the process and make a note of how you change the process. But that's what they did to blend them together.
Well, this was about 7 or 8 years ago, and we had data management technique and then a straight random sample where we based it on the percentage of females and minorities that had applied, and then we would spit out, that same percentage, but a lower number. And I had an HR manager tell me one time that his neighbor was an employee, next door neighbor was not an employee, but recommended that his daughter apply for one of the jobs. And the HR manager said, well, I went through the list that came out on the random sample, and she wasn't in there. And so I just decided to take all the females that had applied. I was like, oh, God, that wasn't the So I figured I'd write a book.
That's under the category of no good deed ever goes unpunished.
Exactly. I was like, oh, my gosh. Anyway, so we are ending on a funny note there, but we do still have a few more questions, and we will get answers to those. And when Casey sent out the slides and a recording of the webinar, we get that information to everyone. In the meantime, I want to thank both Linda and Karen for their information today. It was a very, very good webinar, and I really appreciate your time. I appreciate everyone else staying on for the extra time in the webinar, and I hope you found it as valuable as I did. The interesting topic right now, and we all know that this is OFCCP's bread and butter, are hiring cases, so that's where most of their violations. So I appreciate everyone attending today, and I hope you look forward to our webinars. We have one December 15th on protected veteran definition, and we're also giving an hour to just do wide open question and answers on any topic. So look forward to having you join us in our next webinar. Thank you, and thanks, Karen and Laura.
Welcome, everybody. Have a good day.
Thank you.
Thank you. Bye-bye.
Thank you. Bye-bye.